Hi everyone, welcome to ERISA 101 training. What are my duties with an ERISA plan? My name is Dennis Fisher and I'm Chief Compliance Officer for the Northeast region. I'll be walking you through the materials we're discussing today. If you have any questions, you can reach out to your local Chief Compliance Officer or to me, and we'll do our best to respond to any questions you might have. This is part 4 of the ERISA 101 module. What are my duties with an ERISA plan? So ERISA is well known as a complicated and very technical federal law. But fundamentally, on slide 5 here, we've broken down some of the key aspects that we support our clients through when they satisfy their ERISA requirements. That starts with distribution of notices and delivering information pertaining to how the plan operates so that people understand how this program impacts them. Things such as the annual open enrollment kit that we send out nationally contains the key elements of the notifications that are required under ERISA. Also well known is the Form 5500. The Form 5500 only applies if there are at least 100 participants at the start of the plan year. So that's a common question. It's not an average number during the year. It's a snapshot of how many participants are on the plan on the first day of the plan year. And when we talk about participants, there's a specialized definition here. It's people who are actually explicitly covered by the plan. These are individuals who are actually on the plan. You don't have to count dependents, even though they may be receiving coverage through an employee. And you don't have to count people who are merely eligible but have not actually enrolled. So that's an important way to distinguish who is going to be an employer that there's a 5500 trigger for. Also, we highlight here in bold-faced font ERISA fiduciary duties. That's a critical element of compliance. You have to follow the terms. It's a contract that the employer has, plan sponsor has with employees. There's a duty, and we'll go into this in some detail, that the employer must scrupulously follow the terms of the plan. Also, avoiding prohibited transactions. We'll talk about what that is. Basically, it's a way to ensure that there's no self-dealing so that the employer is profiting from the terms of the plan. And then following claims procedures. Those are legal requirements, step-by-step requirements that the plan is obligated to give everyone the same access to in processing their ability to derive the benefits that they want from the plan. Incidentally, there are special health claims procedures, and there's disabilities claims procedures, and ERISA provides different protocols depending on the kind of benefit that you're talking about. Let's go to the next slide. Okay, slide 6. Who is a fiduciary? As described here on the slide, a fiduciary can be named in the document. Plan administrator or trustee, for example, would be named fiduciaries specified in the plan document. But in addition to that, the requirements under law are much more expansive, so that regardless of the designations that might appear inside the document or in contracts, really it's anyone who's performing a fiduciary function on behalf of the plan, they can become a fiduciary under ERISA. So that really means, does that person exercise discretionary authority regarding the management of the plan? Are they in control of how assets are being spent? Are they giving advice? Those are all behaviors that can make someone a fiduciary. So just because you're not specified in the plan as a fiduciary doesn't end the story. If there, and this is what we specify here in the last bullet, these roles where you have discretionary authority or control, that's functional. That means that by your behavior, by the role in which you are serving the plan, you can become subsumed in that role of fiduciary. So a lot is at stake if you have that sort of role on behalf of a plan. We're going to carry on that idea of fiduciary role in slide 7, where we examine what a plan administrator is, because we often bump into employers who might incorrectly believe that they're not the plan administrator, that the TPA is the administrator. Now, under ERISA, every plan has to have a named fiduciary and a named plan administrator. That makes good sense because under ERISA, there has to be a party that's going to be in charge, a party that will be culpable for operations and have the responsibility to ensure that everything is running as provided in the plan document and complying with requirements of federal law. Now, if the plan doesn't specify a plan administrator, there is a default rule that says that it's the employer. So the employer can never just point the finger and say that that's someone else's responsibility. The buck stops with the employer. Interestingly, we talked about who is a named fiduciary on that last slide and who might absorb that fiduciary role by their operational conduct and whether they have control. So in this second bullet, the sub-bullet, a TPA will usually avoid being a fiduciary except for certain specified functions. So by and large, the TPA is just performing a function on behalf of the plan administrator. It's only if the TPA gets into those stickier areas where they are having and exercising control that they can convert into a fiduciary. So that's something important to consider, because just naming a TPA doesn't mean that they are going to be the plan administrator and that they are automatically a fiduciary. It depends on what sort of role that they are performing on behalf of the plan. Slide 8 asks a great question. Why does any of this matter? We've spent a good deal of time talking about fiduciaries and who they are and how fiduciary obligations can attach. This matters because individuals who are held accountable, to these standards, can become liable where there's a breakdown. So at the top of slide 8, we talk about this, that individuals can be required to make participants whole for losses due to breaches of fiduciary duty. And I guess it's more common in the context of retirement, for example, where there are very substantial, for example, pension proceeds, where people have embezzled and mishandled those assets. Then there are people that go to jail. So it's it's a heightened standard, and there's a lot at stake in mismanaging, and there are, as we note here, the possibility of civil penalties, a variety of other bad things that can happen with someone who is not taking their role as a fiduciary seriously. And there's some best practices that we've described down below. When you have a committee that can tackle these responsibilities together, that can help to validate the decisions that are made, clear about the functions that they perform, that can be a good thing. Also, like with other compliance roles, having training so that individuals who do absorb that role are aware of what's at stake and aware of what the standards are. And then there are other practical safeguards, such as the availability of liability insurance, which we point out here is not legally required, but it can be a very good thing for those that are assuming and absorbing this role. So what are the ERISA fiduciary duties that are expected of named and operational fiduciaries? Slide 9 delineates these, starting with the duty of care. Basically, that's saying that the law imposes a requirement that there's an understanding that the fiduciaries are not going to be able to do everything in every scenario. And so where there is a lack of expertise for a particular situation, then it's expected that the plan is going to recruit someone with that ability so that participants are going to be served and protected. So the duty of care is going to require that there's an awareness of where additional expertise have to be drawn in to address a particular plan situation. The second bullet, I think, is especially important. That's the one that I've had many discussions about. because employers sometimes misperceive the reason for the plan. There's a loyalty to participants and beneficiaries, an exclusive benefit. There's a legal responsibility that the plan operate for the exclusive benefit of the participants. And there are, frankly, employers who have toyed with the idea of attaching a premium to plan participation and trying to drive an additional revenue stream on the basis of the plan. Basically earning money on the backs of participants, and the law specifically precludes that. That's a direct violation of that duty of operating for the benefit of participants. There's also additional responsibility in hiring and recruiting others. So making sure that the people who are supporting the plan in whatever capacity have the ability to execute so that the plan will operate the way it's supposed to. Additional responsibilities to follow the plan document as written. Also operate consistent with the law. That's a crucial one, and one that pops up often in the context of issues like the reimbursement for medical marijuana, for example. That could be an area where state or local law might say that that there is a medicinal marijuana use is permitted, but because the plan operates under ERISA and under the framework of federal law, the plan is not going to be able to reimburse for those kinds of expenses which are directly at odds with federal law. So that's the kind of fiduciary responsibility that we're talking about. Let's move on. 10. And I think that clients love us the most when we're able to offer them practical suggestions. And when it comes to ERISA compliance and operating the plan, then there are some very fundamental practical steps that should be considered. And we outline them here. Very logically, want to make sure that decisions are well-informed, well-reasoned, taking careful steps to review those people that are going to be appointed for roles in the plan, making sure that you can examine them not just on the fees. It's not always the lowest cost that's going to be supportable. In fact, it can be a fiduciary problem to just reflexively pick the lowest cost provider, because if that lowest cost provider is very dicey about what they can provide, then it may actually not be the right choice. So fees for services have to be reasonable, but not necessarily the lowest cost. And we've already emphasized that decisions have to be based on the plan document. Does the language of the plan document authorize the decision that's going to be rendered? It's important that those rules are applied in a consistent manner and without any special favoritism or doing things on an exceptions type basis. So that's going to necessitate becoming familiar with the plan document. Where there's a problem, where there's maybe something that's ambiguous, drawing the expertise from an outside source that will help to arrive at a supportable decision. That's going to be key. Avoiding conflicts of interest. And then something we've always talked about at Hub, and that's having a fiduciary file, some way to record the decisions, explain your work, and to be able to articulate, especially if the plan is ever audited, to communicate exactly why something was decided in a particular way, what were the factors that were involved, what were the sources that were considered, and then that will showcase exactly why the plan decided in the particular way that it did. It's a prohibited transaction. Under ERISA, prohibited transactions represent a specific type of transaction that is a form of self-dealing. And we give some examples. It can be a transaction between the employer and a service provider where they're deriving some sort of financial interest. Maybe it's a husband and a wife, and one is trying to help the other profit through some plan activity. Historically, prohibited transactions, I think, are more commonly associated with retirement and pension than they are with welfare. ERISA, of course, covers both. Um, but in the context of a health and welfare plan, it's critical that those kinds of transactions be examined so that there's no appearance of inappropriate behavior and any kind of self-dealing between a party of interest and a disqualified person. So again, it's someone who has a conflict, basically, is what we're considering here. There is a process, we're not going to, it's beyond the scope of this discussion, where the Department of Labor can be called in and umpire questions of prohibited transactions and see if an exemption might be available. That's, again, typically on the retirement side. But for purposes of health and welfare, be on the lookout for any kind of situation that may be suspicious for self-dealing and some form of profit motive. So here we continue the discussion of prohibited transactions with some specific examples. They're outlined here at slide 12. Any kinds of sales between the property, between a party in interest and the plan, lending of money, moving those plan assets to benefit someone who is a plan fiduciary. That would be an obvious kind of problematic transaction. These kinds of transfers that are designed not to be for the exclusive benefit of participants, but rather artificially structured so that the parties in interest are actually exploiting an opportunity to use the plan for their own benefit. So these are obviously in violation of the ERISA standards. So really, we close on slide 12. Any transaction with a fiduciary is dealing with the assets of a plan for their own interest. Very basic and fundamental violation is where the interests of the participants are being ignored in favor of these parties that they should know better, and they should be behaving to protect the plan rather than to enrich themselves. Slide 13 focuses on a very interesting, and this is an important slide because in the context of health and welfare, there is a DOL technical notice, 9201. It's very famous, where basically ERISA plans are spared from the ERISA obligation to establish and operate a trust. The trust, in the context of, for example, retirement and pension, is designed so that it can hold plan assets. But for health and welfare, usually those are funded through general assets of the employer. A lot of times it's just paying premium and money is just flowing through. And so you don't have the same kind of plan assets that a retirement plan would have. But as we note here on slide 13, some employers think they don't have plan assets, but almost all have some. And in the context of health and welfare plans, payroll deductions, COBRA premiums, rebates like the MLR rebates, other sorts of dividends, those can represent plan assets and they have to be handled with extreme care. The rule of thumb basically is that, for example, in payroll deductions, that a lot of people think, oh, well, I have 90 days in which to spend that. That's not exactly the case. Depending on the capability of the plan sponsor, you're supposed to move those through as quickly as reasonable for that entity. So just because there's a ceiling of 90 days doesn't mean that the employer can hold the payroll deductions and basically float themselves a loan, in effect, by not passing through those deductions right away. The law looks very carefully at how those kinds of plan assets are being handled. And in the context of ACA and the MLR rebates, they raised a lot of very specific concerns about how those rebates should be handled. We have some very excellent materials outlining exactly how the money should be examined, what portion might be attributable to employees and a plan asset versus what an employer might assert a right over. So these are important questions, and they demand a lot of attention. Slide 14 highlights some of what I just described in the prior slide. Less obvious prohibited transactions. Again, the significant delay is a big concern. It's not just that the DOL lays out 90 days to forward the money that's been collected on a payroll from payroll deductions, but really it's the employer's ability. So one organization is not going to look the same as every organization. They're not going to be treated in exactly the same manner. Ford Motor Company, General Motors, these bigger guys, that they have a greater capability to immediately process through the payroll deductions, and so they're going to be looked at differently than a mom and pop enterprise that will have other considerations in how they can collect and process money that has to be paid to the carrier. There is the limit of 90 days. It's got to be collected out of someone's paycheck and processed through within that 90 days, but where there is a delay so that the organization is profiting, that it's being treated as a loan, and that's a type of a prohibited transaction. Another form of a prohibited transaction would be to use participant contributions for inappropriate expenses. You can use them for necessary fees to administer the plan, to operate the plan, to pay service providers for their fees. That's all related to the operation of the program itself. But to the extent that it's used to defer other types of corporate expenses, that raises very serious questions about whether it's a prohibited transaction or not. If there is a question about how money should be handled, then that's a place where there should be a red flag, that someone would bring in expertise to look at that particular question, maybe have to fund outside legal counsel to look at whether a certain kind of expense is justified to be paid from the plan, or whether it's inappropriate to do so. As with so many aspects of compliance, there are important exceptions to the rules. And in the case of ERISA and fiduciary responsibilities, there are categories that don't invoke fiduciary requirements. Those are basically outside of the fiduciary zone. And the way the law refers to this is what is a settler function versus what is considered a non-settler function. And it's important to think of these two different categories, because certain operational moves by the employer to establish a plan, to design a plan, to provide benefits, to decide whether something should be a high deductible plan versus a PPO, the specific benefits that should be provided, those are all settler functions that an employer will consider in its role as an employer. And that's outside of the ERISA sphere and the ERISA protections. Implementation is a fiduciary act, and that's going to invoke these special category of fiduciary rules that we were describing this entire section. Basically, once the plan has been established and designed, then maintaining and keeping it going and paying for expenses related to the function of the plan to keep the momentum going are going to be considered non-settler functions, and those can be paid with plan assets. Whereas some of those settler functions that are required at the onset are outside of the plan and would not be, those would be paid out of the employer's general assets, not plan money, but basically employer money. So the difference of settler versus non-settler is extremely important. So while we spent quite a bit of time talking about ERISA rules, fiduciary obligations, prohibited transactions, and those standard types of problems that could occur. Really on slide 16, we're focused on claims procedures. And because this is the area that will really touch participants, it tends to be the most sensitive. And this is really where you may see participants complaining, seeking to enlist the DOL to challenge the employer, because ERISA, and most recently under ACA, they spell out very specific claims steps, protocols, and protections that are guaranteed under law. So the adequacy and the timeliness of all of these processes are going to be scrutinized, put under a microscope, and typically whenever these issues are examined, it's always done in the light that's most beneficial to the participant. So chances are, if problems will emerge, that they will be tied to some sort of defect in a payment of a claim, and a problem with the procedure where someone is seeking to have something changed or something reviewed, and the employer, the plan sponsor rather, has not stuck to the required, the guaranteed process. And again, there's two. There's one for medical claims, and there's another for disability claims. These are typically going to be handled by third parties, and that's noted here in the last bullet, the TPAs. Fiduciaries, because they're responsible for, ultimately, the buck stops with them as far as plan processes go. It's really incumbent on them to clearly understand the claims process and to proactively understand exactly what the plan is guaranteeing to participants, so that everyone is treated in a fair and consistent manner. There's a reasonable process that's described by the plan, and it's honored in every situation. So this concludes section 4. What are my duties with an ERISA plan? It's part of the ERISA 101 module. If you have any questions, please reach out to your regional chief compliance officer. Thank you for listening.